want to talk to you today about how to get criminal harassment charges dropped. Our firm represents a lot of people charged with criminal harassment, and this is one of the first questions they ask us often is, how do I get these charges dropped? Well, that's an important and vexing question. I'm going to answer that for you today. So the first thing we do when you retain us is we're going to order the police reports. That's the disclosure. All of the witness statements, the videos, every scrap of evidence the police gathered against you, they're going to hand that to the Crown Attorney, who's eventually going to provide us with a copy of everything, including the video statements. As a lawyer, my first job is to analyze that in great detail and figure out every aspect of your case. Like what's my legal opinion with this case? What are the strengths of the case for the Crown, the weaknesses? Can I win this case? What are the odds of winning? What parameters does it fall in? Is it an easy case to win? Is it better than 50-50? It's pretty good. I think we can win at 50-50. It doesn't look too good. This client's guilty. It's obvious. There's 8 witnesses showing they harassed or stalked a woman or a woman stalked a man for that matter. So once we have that, I tentatively formulate an opinion in my mind about the case. And when I say tentative, I want to hear the client's version of events before I finalize that opinion. So, after reviewing that disclosure probably for several hours and looking up any law, if it's a tricky legal issue, because harassment can be tricky. I mean, some things fall between the cracks, and there's a lot of case law about it. I'm constantly studying the case law and applying it to cases, but many cases are cut and dry, either it's winnable or not. But there's ones in the gray area where you need to really delve into the case law. Hundreds of cases across Canada that you need to read on this topic. It's important to have a good lawyer when you handle one of these cases. So I formulate my tentative opinion. Now I'm ready to meet with the client. So I meet with the client and I review the disclosure with them. And I receive their version of events. That's the very first meeting with them. So I get their full version of events. Once I have their version of events, I can tell them, look, I think you've got a good case to win. I'm thinking it's a pretty good case to win. It's 50-50. It's difficult. We might win if we get lucky, or this is a slam dunk Crown case. You should get the best deal you can. I receive their instructions. What do you want to do? Like, do you want me to negotiate the best deal? Do you want to tend to go towards trial? I need the client's instructions before I meet with the Crown. And those instructions may be, look, I've got a winning case here, and I'm going to tell them, I'm going to go try and get this charges dropped. Or a great deal, like a diversion or a peace bond or something like that. So they say, great. And I said, by the way, I need to get your background because that's important. Background's mitigating. In other words, it lessens the possible sentence or increases your odds of getting charges dropped if you've got a great prior background. Look, you've got no criminal record. You're doing community service all the time. You're a very, great person in the community, well thought of. This was a one-time minor incident, that happened. Okay, you got drunk one night and then stalked a person repeatedly or something. It's just a one-time incident where you did some stupidity, or not. Maybe you're innocent. So you give me those instructions, and armed I go with all your background, my thoughts in the file, and I meet with the Crown prosecutor at a Crown pretrial. Now, my goal there, if I think, number one, is there a reasonable prospect of conviction? That's the test. If it's a weak case, why should the prosecutor continue with it? I will try to convince them to simply drop the case. And I've gotten cases dropped many, many times throughout my career. Like I wouldn't even want to count how many criminal harassments I've had dropped, because when you look at it on paper, they don't have much of a case. The police made a mistake by charging. Police were too cautious. They said, we're just going to lay a charge and let the Crown sort out. Well, the Crown should withdraw the case flatly in that. No reasonable prospect of conviction. That's the first step, okay? If there is a reasonable prospect of conviction and the criminal harassment is not terrible, I mean, it's not the most fearful stalking incident for months and months where a person's cowering in terror, but a more minor incident a few times, I mean, the victim's recovered, any harassment's not good, but a minor incident, we can sometimes convince the Crown to divert the charge. You call it what you will. Different counties call it different things. Diversion, alternative measures, which means maybe we get some upfront counseling. The Crown says, if you get some upfront counseling, you've convinced me, Mike, that this is a case for diversion. Upfront counseling, do our good deeds up front and get a report from the counselor. This is a one-time thing. The person's not a danger or risk to the community and going forward. Crown will agree to diversion. So they might agree to a peace bond, where you keep the peace and be of good behavior and stay away from the victim for a period of years. So that's a good result if a person actually did it. I mean, if they're guilty, that's a wonderful result. You have no criminal record. There's mental health diversion as well, where there's mental health courts in most counties, if not all counties now, where if there's a mental health issue, we can often get these charges withdrawn. I mean, the person's just, has a lot of mental health issues, and that led to the alleged crime. And again, the charge ultimately gets withdrawn with counseling and treatment and maybe a peace bond and that sort of thing. Now, what's another decent result if we can't get that? Let's say, the Crown's not playing ball because the stalking, the harassment, the repeated phone calls, the endless criminal behavior which caused such tremendous fear just is too serious. Maybe the Crown will agree, and I can convince them to agree to a conditional discharge where you plead guilty to the charge, the harassment charge, but because of your good background, it's in your best interest and not contrary to the public interest, which is the test for a conditional discharge, that you be discharged on conditions. That means you plead guilty, but you're not convicted, you don't receive a criminal record. However, the judge puts you on probation for 12 to 36 months, usually 12, sometimes 36 in a more serious case though, to continue with counseling perhaps and not to communicate or associate. There'd be a weapons condition. But the beauty of that is, look, it's a more serious offense, it's a good result, you avoided a record, and that record's going to eventually not appear on a criminal record check. It will initially on a level 2 check. On a level 1 check, it shouldn't, according to the Criminal Records Reform Act of 2018. But eventually but it's not a criminal record. Don't get confused with it just appearing on a level 2 check. A level 1 check is a basic criminal record check. It shouldn't show up. A level 2 check is a criminal record check, and a judicial matters check. Well, it's considered a judicial matter. But after 3 years, you'll be able to get your fingerprints destroyed, your file destroyed, your mugshots. It won't be on any level of criminal record check, even a level 3, which is for more vulnerable sector, if you're a teacher or things like that. So that's often a great result for a person who, got charged with harassment and they're actually guilty. So those are the 3 ways to get, the 3 types of circumstances where we can get a matter dropped. It requires a lot of negotiation, thinking. It requires a lot of thinking by the lawyer how to phrase things properly, both in writing and in meetings with the Crown, to mitigate the circumstances, the facts, and the background to get the best possible result for the client. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.